Hello everyone, welcome to GS Core. My name is Abhishiekh Saxena and this session is about GS Mains Advance for the subject of governance and social justice. And within this subject, we are going to take up a very prominent, popular, important, yet very obscure dimension which has not been explored by a lot many books out there, at the same time the materials. That is e-governance and judiciary. Before I get into the substance of this topic and qualify why this is advanced, right, we need to understand certain background of it. Generally, when we talk about e-governance, generally we think of schemes, initiatives, certain portals, right? And judiciary is largely dealt in terms of the Indian polity, right? However, if you look at the questions that are asked in the examination, the questions in particular regarding governance and social justice represent an integrated approach. When I say integrated approach, that is also twofold. In terms of the concepts and contemporary orientation, as well as the intermingling or the intermix of topics. So while we study e-governance as a separate topic as part of regular sessions, right, and judiciary separately, often we see questions alluding to some aspect of governance or government in action relating to e-governance. So whether we relate e-governance with health, we relate e-governance with education, at the same time, the same thing can be related to judiciary, for which a lot of details are not available when we go by the standard material that is available. And hence, you need to wear your thinking caps to actually answer a question like this. Also, if you look at the nature of questions, they get abstract. And even when we have an abstract question related to just e-governance and overall governance aspect, we tend to focus on what executive does. However, the need is to diversify. Why just focus on executive? Why not legislature and judiciary? So things like e-vidhan, for example, regarding legislature and regarding judiciary. So we'll talk in detail about this aspect. So if there is a question which is very abstract related to overall aspect of the governance, then also we can incorporate the diverse perspectives, hence provide some sort of originality, innovation in our answer, which will distinguish the answer from what everybody else is going to write. Also, if there is a question in particular relating to judiciary, we will have enough ammunition to fire when it comes to addressing a topic like this. Also, from the angle that fourth industrial revolution has broadened the scope for e-governance. So it is not just about filling an application or applying for a goods and services or the government releasing an app or a portal. It is certainly broad, right? So this is something which needs to be kept in mind as part of advanced learning, to do this as well as this. Okay, so that is the background under which we are going to talk about e-governance and judiciary. Now, to supplement this and further to the background, if we look at this under the light of broader aspects of e-governance and technology, so the traditional aspects would involve the models that we largely get from second ARC or other models that are available, that is G2G, G2B, G2C, G2E, right? And when we look at this, we generally have a very elementary understanding, and then we come up with certain examples or a portal. And that is how we largely conclude e-governance, mapping out challenges and limitations. We do not dig deeper. But at times the questions demand us to dig deeper. And I'll tell you how that can be achieved. Also, when we look at governance, which is an interplay of state, market, and civil society operating in concert in a networked approach, to do what? To service public interest. So when we talk about state, are we only talking about executive? Largely, the discourse remains around executive. But why so? The examiner can surprise you and ask questions regarding something beyond. Okay? When we say we need to look beyond the traditional approach, that is the tools of fourth industrial revolution, whether we talk about blockchain, AI, crypto, and whatnot. So we certainly need to broaden the horizon. And when we look at governance serving public interest, we will have to look at all the organs of the state, not just the executive. Also, the journey which is from governance to good governance in light of certain cardinal values: consensus orientation, transparency, accountability, equity and inclusiveness, participation, responsiveness, rule of law, efficiency and effectiveness. Right? So this journey has to be marked. So when we look at judiciary and governance, or the idea of judicial governance, this has to be looked at holistically, that how this actually plays out here in the light of the tools of fourth industrial revolution and e-governance in general. Sorry. Okay. So after giving this background, let me qualify this through certain PYQs so that they can help you understand that how interlinked the subject is and how an advanced orientation helps you write better answer. So this is a question which I am giving from 2020 MAINS UPSC examination. The emergence of fourth industrial revolution, and within bracket UPSC writes digital revolution, right, has initiated e-governance as an integral part of government discuss. So while the conceptual underpinnings will remain, the contemporary ideas have to be given. And when you look at e-governance in general, the vanilla answer that most of the people are going to write will fetch you some marks but will not give you the edge. So that is needed. Another sample, and that is from the year 2018. E-governance is not only about the utilization of power of new technology. See, new technology, and not just the digital aspect, but also much about critical importance of the use value, and UPSC writes this in quotes, use value of information. Explain. So if you look at questions like these, they represent a very abstract orientation, just like I said. So when you will write about e-governance and just mention, okay, the models are there, a definition of e-governance, will it suffice? It will just be an ordinary answer, rather very ordinary answer. Similarly, if let us say these aspects are asked in conjunction with, let us say, health, education, or judiciary, how we are going to talk about it? Or if it is an abstract, should we only limit our scope to executive? Why not broad base to legislature and judiciary? So in this light, the e-governance in judiciary is important. Now, since I hope all of you now have the background that why we are taking up this topic and why this is an advanced topic, let us move substantially into this particular realm. So if you look at, technology is shaping the world now. Right, and governance being a very ecological, being a very contemporary idea, that it gets affected by the changes in the society and the world. At the same time, it impacts the society and the world, and the basic idea of state, market, and civil society working in concert, and this journey from governance to good governance under the light of certain values, consensus orientation, accountability, transparency, participation, equity and inclusivity, efficiency and effectiveness, responsiveness, rule of law. So this is an acronym, CAT-PU, right, for all those values. So always remember, the basics are never going to defeat you. So remember the basics, and through basics, we will try and reach to the advance. So while this is impacting, the technology shaping the institutions, how they work, the government in action, right? Also, the penetration of these digital tools is getting ever pervasive in every aspect of human life. And if we use these tools to actually solve the people's problem, we are carrying out effective governance. And if we are using these tools to solve the people's problem under the light of certain values, having transparency, accountability, responsiveness, etc., then we are carrying out good governance, right? And hence, the technology or e-governance in our discussion assumes a critical position wherein it can be harnessed to deliver governance on the ground on the far more effective side. And hence, it is incumbent upon the state and the institutions of the state as well as other stakeholders to embrace this idea. Also, we have seen how e-governance has emerged as a go-to tool in the hands of the state to deliver public goods and services. Whether it is the direct benefit transfer, right? Whether it is about Aadhaar, right? Whether it is about platforms like Umang, etc. All of them are digital tools, right? But largely we see it is the executive or the public goods and service delivery that is related to the e-governance. But one area that gets obscured is the judicial or the justice delivery. It still continues to be a relic in its approach, where it is still marked by traditional processes, long processes, cumbersome procedures. Can the digital technology be used to simplify it? Especially in a country like India, where there are so many legal disputes, both involving state as well as outside the state periphery. Okay. So judiciary, we have seen, has been somewhat slow sorry, in adopting this e-revolution. This e-revolution, while the world is getting digitized, the forces of economy, efficiency, effectiveness are ruling the roosts. The judicial service delivery or the justice delivery system is still marred by certain problems. High cost of litigation. I mean, it is very relatable, and you all of you can relate to it as well. That once somebody or some family member falls into a judicial dispute, then it is a forever thing, where the process becomes the punishment in itself. And that is the crux of the problems of the judiciary. So can e-governance bridge this? Can e-governance bring that healing touch? Yes, it can. And we'll discuss how. Right. So the high cost of litigation, pendency, right? Shortage of vacancy, shortage of judges. All these issues dominate when we talk about justice delivery system. So while clearly there are supply side issues, right? But can we temper the demand? Can we use technology to temper the demand while the supply side issues like the appointment of judges, etc., will have its own gestation period, will take their own time? The technological intervention can bring about reduction in cost, reduction in pendency, thereby, if not being a panacea to the problems or to the woes of the justice delivery system, it can still give a healing touch, a sense of relief, right? And hence, digital interventions and wider technology infusion is necessary. If you look at this thing, the problems were always there. The digital technology has been around for quite some time now. But the problem got exasperated. When? During. So what was the trigger? Trigger was COVID-19 pandemic, which brought to fore the limitations. When the physical access was limited, then there was an emergent need, right? And hence it actually pushed judiciary to go digital, right? That is why you see even today there are digital live telecasts of public hearings in the courts. At least the Supreme Court is doing it, right? The Supreme Court is doing it. Recently, when there was an argument which was going on in the court about the Article 370, and a famous lawyer, Kapil Sibal, was representing, and Chief Justice of India, Justice D.Y. Chandrachud, was also there on the bench. So it was live telecast. Okay. So COVID-19 pandemic acted as a trigger that now the inclusion of e-governance or digital technology in judiciary is almost inevitable. Right? Though even before the pandemic, there were measures like e-courts, which was a so-called mission mode project, but we never saw it reaping the true fruits, right? And hence it was realized, the reality struck on the face, that it is now time to go digital, right? So some baby steps were taken, like I said, e-courts, but they were not big leaps to bring about the inclusion of technology in the justice delivery system, right? So initially, if we look at the story, how the technology was there were websites. Some orders used to be put on the website, and the scale of the absorption of technology by the justice delivery system was very, very limited. After the Telgi scam, there was this digitization of stamp papers, right? Very small things that you can pay stamp duty online and get a stamp paper, right? And we saw that this judiciary, almost keeping a pause on the digital activities, and largely it was BAU or business as usual. However, if we look at the potential, there is immense potential where this technology can actually shape and bring ease of justice delivery. And bring ease of justice delivery. For example, online filing system, e-summons, a case tracker for stakeholders, right? At times the government, the private parties, and multiple parties are there to a litigation. Okay, data banks for lawyers, researchers, academics to reference, cross-reference the cases, right? As well as you will have to understand that while there is a Supreme Court, High Court, and other subordinate courts, there are often cases which are transferred, and the records have to be physically brought. So the seamless flow of information can be brought about by e-transfer of file or e-transmission of files. Also, the courts themselves seek a lot of information from the government during the course of a litigation, and sometimes they have to be handled in sealed covers, sometimes this, sometimes that. So all these systems can be integrated, and the government, just like the courts pass on the information to other courts, can the government also transfer the information? Yes, it can. So there can be mechanisms, there can be frameworks which can be created. So now the lawyers, the stakeholders, the researchers, the academics, even the judges, students can have a holistic view and use the power of information. at the same time. The data which is there can be mined, can be analyzed. Data analytics can be used to bring about certain tangible deductions, like what kind of cases are most pending. If a judicial intervention is needed, so that in a summary manner a lot of cases can be closed in a satisfactory manner, they can be done. That same data can be a guide to the civil society for advocacy, for marking citizen spirited campaigns, for other stakeholders to gauge the economic impact. A lot of money is stuck in litigation. So lot of logical deductible analysis can be made. Right? Also, it will cut short the time in the judicial proceedings. Okay. Now, why all this becomes significant? This is all said and done. But let us look at the hard numbers that actually make the case for more technological intervention. And it should not be just the COVID-19 pandemic which acted as a wake-up call. Now, if you look at the judiciary, it is overburdened. Not just burdened, but overburdened. And that is partly to the sheer population that it has to cater to. Right? And partly due to the cumbersome procedures. Remember, I talked about the process becomes the punishment in itself. Because these procedures largely date back to the colonial times. They are not in sync with the present day demands. Right? And most of these procedures have largely remained unchanged for 7 decades, more than 7 decades of our independence. Approximately 20,000 judges are there in the trial courts, shouldering the burden of around 30 million pending cases. Right? While more than 43 lakh cases, right? So more than 43 lakh cases are pending in high courts. And this is, I am just talking about the subordinate courts, the trial courts. 43 lakh is the pendency in the high courts. Right? And more than 8 lakh are a decade old cases. Right? So these numbers that you see are highly skewed considering the manpower that we have in judiciary. Right? And hence that brings the urgency to bring about some reforms. Yes, the supply side will take some time, but the demand side can definitely be tempered to reduce this pendency and burden. Right? There are issues and limitations with technology as well, as technology is value neutral. It cannot exercise judgments, but it can give you certain facts, certain synthesized information, right? And hence this technology should be used in a manner to simplify the procedures, lessen the burden, lessen the pendency. Okay? Otherwise, if this technology will be used in a blanket blinded manner, it will take away the powers from the citizen and it will make the technology the master of the man, which is not desirable. Also, there are bottlenecks, that whatever the workforce is there, that will have to be skilled in this judicial delivery system or justice delivery system. That workforce will have to get skilled to use this technology, to maintain the e-records. Example, to maintain e-records. Because you look at the state of affairs in the subordinate and lower judiciary, the records are very poorly maintained. Right? Also, the intricacies like recording of evidence, etc. So that will require amendment to the Evidence Act, so that a digital evidence collection can be maintained. Okay. Also, all of this has to be bounded to a technology backbone, so that even the litigant and the relevant stakeholders can have the access to it, to the counsels of the respective litigating parties. Right? And this is the gamut of reforms that are needed, the technological reforms that are needed, and that is why there is a resistance to change, because this will not only require installation of computers, this will require the reorientation of the attitudes, the aptitude of the functionaries in the judiciary. Right? All this is marked by other challenges. For example, the internet penetration, or rather the stability of it, the functional literacy, amongst the citizens. So while you can use e-filing in urban centers, tier 1, tier 2 cities, the rural population, the mass of India is still not functionally literate, and the internet penetration is not that stable, widespread and broad enough that you can make e-filing mandatory, just like you have made the passport application mandatory through e-filing route. You cannot do that. Also, the security of data and privacy related concerns are there. Data privacy bill has been on the anvil, right? So a tamper-proof system should be there. So if it is a digital evidence, another party can tamper it and put the case in one's favor. So a tamper-proof system is needed. So this debate between the access to other stakeholders as well as a tamper-proof system, a balance has to be struck. Right? Also, while the e-courts mission mode project provided computerization and interconnectivity amongst the courts, right? However, no open data policy exists. While we have seen open data frameworks like India Stack coming up, but still regarding judiciary, no open data approach has been there. You have Live Law and other pages who report, that is it. But from the institution itself, from the judiciary, no open data approach has been followed as yet. So these are the challenges which actually face the excess of judiciary, or the infusion or the barriers to the infusion of technology in the judiciary. However, there are certain green shoots which are available. solutions are pretty, they're not pretty easy. They are complex because you will have to encounter all those challenges. So while I talked about the supply side challenges, yes, they are going to remain for some time. At least if the government, the executive and the judiciary in collaboration decides to, broaden the envelope. For example, the National Judicial Service or All India Service, right? Appointment to the judges being institutionalized and brought out of the collegium system. The attempts have been made, but at least the technology can be used to temper the demand side and lower the burden on the judiciary. Make the judiciary less cost intensive, less time consuming, more efficient, more open, more transparent. So all the values of good governance can be brought about through the use of technology. However, like I said, it is not all a black story, right? There are certain green shoots available. For example, the e-codes. So it is also, like I said, an integrated mission mode project, right? And it is being implemented in high courts and the subordinate courts of the country. If you look at it, the seeds of it can be found in the national policy, and action plan for implementation of information and communication technology in Indian judiciary 2005, and we are in 2023. So many years, right? So there was an e-committee which was set up by the Supreme Court of India, and this e-committee was constituted in 2004 to basically bring about a plan so that ICT can be integrated with judiciary, right? The Chief Justice of India acted as the chief cum ad hoc chairman, right? Also, this is a green shoot. So it is finally seeing light of the day that most of the high courts are now digitally connected, right? Then there was this DAX, Center of Excellence for Law and Technology, which was incubated in IIT Delhi. IIT Delhi, right? It has initiated a project titled Evaluation of User Interface and User Experience for select Indian High Court websites to make websites more user friendly, more intuitive, right? And other two projects are case flow management, in India via simulation, modeling, and the check bouncing case analysis. So cases like check bouncing, etc., regular, issues around which litigations are framed, they can be handled well because there the facts are pretty clear, right? Largely they require less human intervention, less subjective interpretation, in comparison to other cases. So it was in the pre-rollout phase, right? And the research is still going on, right? However, this is too little too late. A stimulus is needed so that widespread research on technological interventions that can be brought about in the justice delivery system needs to be financed, so that we can get quicker results, we can get wider, array of options. Next, LIMS. Okay, it stands for Legal Information Management and Briefing System. It is an initiative of Department of Legal Affairs, Ministry of Law and Justice. Okay, so it is a web-based application for monitoring cases involving central government. You are aware that government is one of the biggest litigants in the country in terms of the sheer number of cases in which the government is a party, right? You would have heard that government comes up with various schemes so that litigation and disputes can be reduced, right? Regarding tax disputes, regarding other disputes related to financial transactions, contracting, Vivad se Vishwas scheme, etc. So while that is on the executive side, what is being done on the legal side, right? So this system actually brings in transparency for the other stakeholders, right? So while the digitization of courts is important, it is equally important to digitize, automate and monitor cases from within the ministry and the department. And that is the reason why LIMS was actually commissioned or put in place. Okay, there are obviously several models that can be emulated. For example, e-filing. E-filing, right? So while usually there is a paper-based method to file a case, right? The e-filing can go a long way in cutting the red tape, in reducing the cost. Imagine a poor person has to travel from a remote village to the nearby town or a city to actually get the concern or file a case. If it can be done remotely, also the synergy will be needed along with other e-governance measures. For example, in this scenario, a common service center can be enabled as an e-filing post, right? So things like that. However, this is being implemented in certain courts, but it is limited in its scope. Also, this will eliminate the need to go to registry, get things notarized, etc., etc., thereby reducing cost, enhancing access, enhancing availability, while that registrar or that notary official will only be available for the desired amount of time, working hours. This can be done anytime. Like you can now file a passport application from the middle of the night. You can simply do that, right? So it will reduce cost, enhance access, availability, as well as transparency if it is integrated with a case tracking system. Okay. The notary can also sign the document using an e-signature. So like I said, it will require a lot of many improvements. The reorientation will be needed. Also, why not things like arbitration? So arbitration has come up as a means to reduce the burden or the pendency, right? Creating a win-win scenario, right? So why can't this process be also available online? So things like online arbitration. So the appointment of the arbitrator, just like you have e-doctor or you consult doctor on a video call, why not online arbitration? That will actually plug in a lot of gaps. A formal office, a formal court will need a lot of infrastructure, whereas an e-arbitrator can simply be sitting in a cabin and you can have a call center like approach where multiple arbitrators who are empowered are sitting. So in less infrastructure you can deliver more speedy justice, less costly justice, right? And the challenge to the award can be done online. If you look at the present scenario, online arbitration agreement is valid as per Section 7 of the Arbitration Act. But do we have enough infrastructure? Do we have enough online arbitration mechanisms in operation? The answer is no. But if we can do this, and we can do this pretty fast, we can drastically reduce the demand side burden on the judicial service delivery. Okay. There are easily verifiable trails that can be there, email trails can be there, right? Other means of communication can easily be verified. Also, the idea of online dispute resolution. Online dispute resolution. So it can be a supplement to the ADR mechanism which already exists in the justice delivery system. That is alternate dispute resolution mechanism. So mediation, negotiation, and it will reduce the dependency on the courts, enhance the access and lower cost. For example, if you look at Singapore, UK, Australia and US have such facility. Next, why limit to e-governance, just the monolithic idea of e-governance alone? Why not use AI, right? OpenAI, ChatGPT, a lot of you might be familiar, right? So things like SUVAS, that is Supreme Court Vidic Anuvad software. Well, if you look at the language used in courts, it is largely English. And the litigants who might not know English are at the mercy of the lawyers. Whatever lawyer tells them, they believe. And at times they get tricked, they get fooled, right? Not to say that law is not a benign profession, it is benign, but these instances are also there, right? And they end up paying fee after fee after fee for hearing after hearing. The lawyer keeps on taking the hearings. This increases the pendency, increases the cost of the justice delivery as well as the frustration, right? The matter remains unresolved. So it's a neural machine translation tool to translate orders and judgments from English to 9 vernacular languages. It was launched in 2020 so that the common man can also understand, right? Okay. So to make this effective transition, like I said, there are laws, the Evidence Act, etc. Amendments have to be made, right? And this digital transition has to be a protracted yet effective process, and it should be done in a time-bound manner. So, an overall digital framework for judiciary is something that is the need of the hour. Blockchain technology and artificial intelligence can be used to secure the data, to secure things like e-evidence and provide a tamper-proof electronic backbone. Also, there are other benefits. While physical records are prone to degradation, they are burnt, eaten by rodents, etc., and are easily tamperable. Also, the judiciary in India requires the use of voluminous documents. It has an environmental impact, but that's a very, very subplot in our discussion. But also, this sheer bulk of document are difficult to transmit. Remember the Ram Mandir case. So many thousands of documents, they had to be transported in a truck from the trial court to the High Court to the Supreme Court. Such a costly, time-consuming process. It is also costly, time-consuming and not very foolproof. Also for small things like payment of court fees. Okay. So filing fee and other related transactions, security deposit, bond, etc. So that all will get also plugged via use of technology. So that will, go a great deal in bringing about ease of justice delivery. Right? And hence, it is something which is needed. Also, these data already generated, but in a non-digital form, once will get digitized, and new data when it will generate it will help the third party players, the governance paradigm working at its best, to develop APIs. Look at how APIs for UPI and India Stack are coming up, so that others can also plug and play. So it will make the justice delivery system far more inclusive, broad-based, democratic, and hence will enhance the legitimacy of the system as well, make it more benign, people-friendly, as well as efficient, effective. And it will also help in plugging the infrastructural loopholes, right? And will bring about open court protocols, making justice delivery system less complex. If you look at the World Economic Forum in 2018, stressed on the role of IT in various fields, including the judiciary. But that cannot happen without a proactive orientation from the decision makers, the judicial machinery, the state machinery. They have to work in concert with other players, solution providers, civil society, so as to make the process, or to bring about, as I have said repeatedly, the ease of justice delivery in India. Right? So this is how we can link the technology and the benefits that it can bring about in a particular sector. Right? So we took up judiciary this time. Right? There will be more in the advanced classes. Thank you.